extracted it here, we'll see.
My Lords, if I may just have 1 minute
Yes.
to point out the case law that already exists. There are a variety of high courts have found that nothing can be read into this provision. In Nadidi Eze, he was an illegal immigrant and they said there is no bar in this particular section, etc. In Yossi bin Ari's case in Israel, they said that the registration official is not competent to determine whether there is a legal or social framework.
Nandi, thank you. Yeah, yes, now we'll hear.
I'm extremely grateful, Nandi.
I'll get right to it, my lord. Your lordships had raised certain questions yesterday. My endeavor and my time will be only to address those questions. Whatever points I've raised in my submissions earlier are already there with your lordships. I had also circulated, I should say, an additional note this morning. It's the note dated 26/4/2023 in response to queries raised by this honorable court during the hearing of yesterday's date. Do my lords, it's volume 10 of the folder titled Written Submissions. That's the first folder.
Yes.
Do my lords Justice Bhatt and Justice Kaul have it?
Yes, I have got it.
I'm most obliged. I'm most obliged. As I understood the proceedings, can I move on?
Separate folder. Where is it separate? Don't download it again. Just check it.
While my Lord Justice Kohli's laptop is being uploaded, can I just summarize what I've understood?
Please go ahead.
Please, my Lord, I'm obliged.
Yes, please.
Okay. My lords. As far as the constitutional issues were concerned, those were clearly set out before my lords, Article 14, 15, 19, 21, etc. The case law is also clear before my lords. There was then a question of interpretation of the statute. Now, there are various provisions of statutory interpretation in my lordship's arsenal, both the principle of updating construction as to how to read, reading up, reading down, and so on. The question which I understood falls from my lords is how far my lords will go in their interpretation of the statute. At the heart, there are certain provisions of the SMA. So we left out personal law in terms of the Hindu Marriage Act altogether. At the core, there were certain provisions of the SMA, Section 2, Section 4, Section 27, 36, 37, and so on, which were read by my learned friend, Dr. Singhvi. And there, the proposition that broadly has emerged is that my lords can read the words husband and wife, bride, bridegroom, etc., insofar as they occur in the statute, either in a gender neutral manner or by reading in the word spouse. So the general proposition then is that there is an act of reading in, an act of expansion of the statute to include a hitherto excluded class, which both updates the statute in terms of present day reading and understanding of relationships, and secondly, brings it in tune with our current understanding of the Constitution. Now, my lord, the questions which fell from your lordships yesterday pertain to, firstly, Section 21A of the Special Marriage Act, which I've sought to address in this note I've now submitted. And the question that follows is, to what extent do my lords then retain personal law for LGBTQ couples who may marry under this statute, who may be similarly placed to other couples, that is, opposite sex Hindu couples to which section 21A applies? That is the first question which your lordships raised yesterday and which I believe is troubling your lordships. The second question is a more general question, that when we look at general civil statutes that relate to the rights, what we are so far calling the rights and obligations of marriage, to what extent will those apply to LGBTQ couples who marry under the Special Marriage Act? So we are confined, my lord, to the Special Marriage Act. But the question is, what are the consequences of the interpretation that would follow if your lordships were to decide in favor of the petitioners? Now, I will take my lords through my reasoning as set out here for both the first and the second question. But the conclusion I'll come to is this, that your lordships cannot decide every question today. The statutes, whether we talk of gratuity, as my lords did yesterday, pension, there are any number of benefits that and obligations that flow for married couples, or whether we speak of the consequences of 21A, these, my lords, are complex statutes, and LGBTQ couples, as it fell from my Lord Justice call on day one, LGBTQ couples will come to your lordships, and more importantly, in fact, to the courts below, to family courts, to civil courts, and to the high courts with, with questions of statutory interpretations as they raise claims and they seek the protection of law in the same manner as opposite sex couples do and have done now, perhaps since the codification began of matrimonial laws starting from the early 1800s onwards. So we are no different in that regard. In fact, if I may say, what we ask for today is the right to not be different, that our differences stand ameliorated by our inclusion under this one statute. So what your lordships have said so far is that the application of the Special Marriage Act would be expanded, and then it would apply to us as it does to all other couples. That, my lord, is my submission, would continue to be the reading for 21A and for other general civil laws. And what I would submit, my lord, is that a declaration, both a positive declaration in the form of mandamus and a negative declaration in the form of prohibition, would go a long way in easing the work of the courts below in the interpretation of the statutes, as they must now commence doing in the work that they will have to come. If my lord will see, I have set out that declaration at the very beginning of the note. It is first, my lord, do my lords have it? In paragraph 3.
Paragraph 3. Yes.
My lords have it? Justice Kaul and Justice Bhatt?
Yes.
I'm obliged. I'm obliged. So we seek, my lord, first the positive declaration that a marriage solemnized or registered, it would be solemnized, I apologize. Marriage solemnized under the SMA 54 and the parties to the said marriage shall be entitled to all the rights and obligations conferred on a married couple or a party to such marriage under any other state or central law, notwithstanding the gender identity and sexual orientation of the couple. And your lordships would also, I propose, give a negative declaration binding the state, that the state nor any authority of the state shall deny rights and obligations conferred on a married couple or such party, and then the formulation is the same, under the Special Marriage Act only on the grounds of sexual orientation or gender identity.
Yes.
With this groundwork in place, my lords, I'll now come to the first question which fell from your lordships yesterday. And my lords, let me say, it is not a light question. It is not a question to be easily decided. It is not a light question for us to consider either, to contemplate. As far as section 21A is concerned, I would first submit that on a statutory reading, in terms of the application of the principles of statutory interpretation, which your lordships will consider, 21A will apply to same-sex or LGBTQ married couples who marry under the SMA in the same manner and with the same force as it would apply to an opposite sex couple. Now, for my lord's convenience, I have actually set out the section in the note itself, but we can take it from the statute as your lordships prefer. May I read for your lordship's
Yes.
benefit? It's, my lord, at page 5 of my note. There's a table set out, but otherwise, if my lords have it, I'll just go ahead. Special provision in certain cases. Where the marriage is solemnized under this act of any person who professes the Hindu, Buddhist, Sikh or Jain religion with a person who professes the Hindu, Buddhist, Sikh or Jain religion, section 19 and 21 shall not apply, and so much of section 20 as creates a disability shall also not apply. Now, my lord, let's read the chapter starting from section 19. Section 19, my lords, the marriage solemnized under this act of any member of an undivided Hindu family, an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religions shall be deemed to effect his severance from such family. And let me say, my lords, that the membership of such a family is not something which we take lightly. It is an important part, my lord, of the way in which we see ourselves as members of the family and as society. But, my lord, section 20, subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property as a person to whom the Caste Disabilities Removal Act 1850 applies. I'll take my lordship to the Caste Disabilities Removal Act also. Section 21, succession to properties properties of persons married under the Act. Notwithstanding any restrictions contained in the Indian Succession Act with respect of its application to members of certain communities, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purposes of this Act shall have effect as if Chapter 3 of Part 5, special rules for Parsi successions for interstate, had been removed therefrom. Now, my lords, what is the overall effect of this chapter? Firstly, upon marriage of a Hindu, Buddhist, Sikh or Jain to a person who, in light of section 21, is not a member of that faith, you are severed from the joint family. Secondly, my lord, these disabilities under this Caste Disabilities Removal Act, my lord, of 1850 is saved under section 20. Thirdly, my lords, I am removed from the operation of the Hindu Succession Act if I marry a non-Hindu, and now placed under the Indian Succession Act, as fell from my lords yesterday. But 21A, if we come back to it, it has the effect, firstly, of saying that 19 and 21 will not apply to me if I marry another Hindu. And secondly, it does not apply to non-Hindus, that is, persons of other religions who may marry within their faith. But 19 and 21 apply to those persons.
Ms. Kaju,
My lord.
I think there is one caveat there.
My lord.
Whereas you are right on the first part, the second part will have to be seen loosely, because you are presupposing that there could be other two same-sex couples from the same religion.
My lord.
You have a Christian and a Muslim.
My lord.
Christian and a Parsi, or a Jew and a Muslim, or whatever. So
My
all
lord.
limitations are there,
My
which
lord.
means to that extent you will have to look into the provisions of the Succession Act, concerned provisions of the Succession Act to start with, and other personal laws. Now that is
My lord.
one complication. And the second is, you are very right in straight away stating that the Hindu Succession Act will apply, or whatever laws of Hindus will apply to same-sex couples who are both Hindus. But that means necessarily, willy-nilly, we will have to interpret. And there, like all of you keep repeating, life doesn't wait. So if there is an unforeseen circumstance like an accident in the absence of a will, or something else, then necessarily the spouse stands excluded. Either Section 8 or the rules of succession of females, or we don't know what other complications are there in other provisions.
And may I say, my lords, perhaps today we cannot know. And we must, I say this with all humility, having considered various aspects of this matter for many years, that all aspects of or questions which may arise before the courts are not clear to us today, as they are not in any case. Your lordships have time and again gone back to the institution of marriage as codified under various statutes and read in various nuances which arose with the passage of time. So as fell from my Lord Justice call, these questions we will be here time and again. But as far as this question which my Lord Justice Bhatt raised, yes, there will be couples who are LGBTQ and, my lords, who are interfaith couples. And there, my lord, 21A will apply to them as an interfaith couple. And there will be couples, my lord, who are Hindu and LGBTQ. And there, my lords, 21A will apply to them as a Hindu couple. Your lordships are not required today to further read the act beyond reading in and explicating the word spouse.
We look
or,
at,
my lords, my
yes,
lord,
Miss Karju,
my lord.
then jurisprudence of this court, which has dealt with provisions of law and their constitutionality, has never isolated one provision. You
My
take
lord.
it to minorities in the field of education. When an enactment is there, the organic whole has to be seen in the context of a challenge to the concerned provision.
My
Whether
lord.
Old Control Act, which was seen in the 60s, or even Frank Anthony, which examined the entire provisions of the Delhi Education Act to see the impact on one section. So there is an organic whole. So to isolate one would not be in consonance with this the approach of this court. That would be leaving things half done, mostly undone. Therefore, how this has to apply will have to be ultimately taken on by us at one go. That's one way of looking at it. All of you have been consistent saying that these are battles which will be fought later. But that does it absolve us of the duty of constitutional the obligation of seeing and considering doctrinally the impact of one provision over the other or many provisions over one? That you will that we will have to keep in mind.
My lords.
All of you have given one picture that
My
I
lords.
the rest look at only this, and this is what we want.
May I submit?
Actually articulated the positive and the negative part. So I think it in a way summarizes the entire let's say project.
May I say, my lords, that my lord may be right. As a matter of constitutional explication, the constitutional underpinnings must be taken through to their logical end. But my lord, as far as one provision or the other is concerned, I may say that in my own reading of and research into 21A, aside from one judgment before the Honorable Delhi High Court in 84, we did not find any other challenges, my lord, to the constitutionality or otherwise of 21A. I would submit that it poses no problem because it is a part of the seamless whole of the statute as it stands today in light of the legislative developments that have taken place since 1850. So if my lords will permit, I'll come to my second point, which is on the evolution of the law of special marriage, which commenced, my lord, in 1872. And prior to that, my lord, we would just shortly consider the Caste Disabilities Removal Act of 1850. So if my lord.
You know the questions that we have asked. You just formulate your points.
My lord.
And then what ideas you have, what
my lord.
suggestion you have,
my lord.
you can just
my lord. I'm very.
right away. You will be able to easily appreciate that.
We wanted the other side to begin at 12.
Now
I think we now start. If we can just formulate, we'll ask the others also to formulate 2 or 3 submissions, and then we just.
I bow down, my lord. So if my lords will just briefly consider, then I'll come straight away to the second portion of my submission on 21A, which is the legislative history of the Act. And I'll quickly take your lordship through it. I won't trouble your lords with my note. In fact, the short point is this. In 1850, my lord, the British legislature introduces the Caste Disabilities Removal Act, which says that notwithstanding any loss of caste, excommunication, etc., the laws relating to property and other benefits which flow from customary law will continue to attract to a person. Thereafter, my lords, comes in 1872 the Special Marriage Act, as a result, my lord, as I understand it, of certain demands by Brahmo Samajis who said at that stage that they were not Hindus. And these were live questions, my lord, before the court as to who was included within a Hindu, within the understanding of the term Hindu, and who was not. And therefore, my lord, when the act came in 1872, since a need was felt, as is felt today, that no community can be without a law of marriage, this statute required that a person give up their religion, surrender their religion, and therefore it's stated, I've set it out in the tables, that table A, my lord, at page 4, that marriage could be celebrated between persons neither of whom profess the Christian or the Jewish or the Hindu or the Mohammedan or the Parsi or the Buddhist religion, etc. So it required me to renounce my religion. Thereafter, my lord, in 1872, in 1923, comes Act 30 of 1923, which amended the provisions both as to who could marry under the act, and secondly, my lord, as to the restrictions on personal law which applied. So, my lord, if my lords see, the first part was retained, that for certain communities, they still had to give up professing their religion. But now, the underlined portion, that marriages could be conducted between Hindus, the Buddhist, Sikh, Jaina, Hindu, so and so, or between persons, each of whom professes one or the other of the following religions, that is the Hindu, Buddhist, Sikh, or Jain religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And my lords, under section 25, no person who adopted under this law would have the right of adoption, who married under this law would have the right of adoption. And under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now, for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 19, 20, and 21, which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of Section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under Section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances, to which persons? Those are, my lords, questions which, as my lord Justice Bhatt perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this. My lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying from a series of cases in Lata Singh's onwards that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples, as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court nor I would humbly submit the state should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I have received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon, you name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws, the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws, for example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender-neutral fashion. And my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That, your lordships have held on numerous occasions, is constitutionally untenable.